Copyright and its detriment to user-generated content. Copyright law began in 1790 with Article 1, Section 8, Clause 8 of the Constitution. This clause is the basis on which all U.S. copyright-related law is expected to adhere to. Since 1790, copyright terms have been expanded 4 times, from an initial 14-year term set in the Copyright Act of 1790 to the life of the author plus 70 years in the 1998 Copyright Term Extension Act. In our digital age, there is one central act that guides copyright law online, and this is the Digital Millennium Copyright Act, or DMCA, of 1998. There has been no new digital copyright legislation for the past 27 years. In the place of actual legislation, when new issues of copyright's application on the internet have arisen in the courts, judges have been left to infer how the written law should be applied. Their extrapolations and the decisions that result create what is known as case law. The case law surrounding copyright in the U.S. is not only a mess, but also a danger. One of the most detrimental of the case laws has been and continues to be contributory copyright liability. Here, a movie company was held secondarily liable for adapting the storybook Ben-Hur, and from this case, the undefined knowledge standard was created. This standard holds that if a company has knowledge of illegal activity, then they may be held liable as an accessory to the crime. However, knowledge was never defined. The Electronic Frontier Foundation, a long-running nonprofit advocating for internet freedoms and protections, brings up the confusion caused by the courts turning to patent law's definition of contributory infringement. While the courts carried over the definitions of what made someone liable for infringement, they did not carry over the concept of active inducement. In patent law, active inducement requires a claim of infringement to be supported with proof of the accused displaying a, quote, very high level of intent. Because the concept of active inducement was not carried over to copyright law, there are no safeguards against baseless claims of infringement, nor definitions to frame what contributory liability even means. All of these problems have culminated in a dangerous level of power allotted to copyright holders. This can be seen most blatantly in the Supreme Court's consideration of the ongoing Cox v. Sony case. In this case, Sony is suing Cox, the internet service provider, under contributory infringement, claiming that Cox is liable for thousands of internet users' illegal music downloads. Cox is being sued for $1 billion. By the court's consideration of Sony's claim, they are positing the insane perspective that, under contributory liability, Cox and all other internet service providers are responsible for preventing and prosecuting all infringements occurring on their service. This would not only grant copyright holders even more power, but also put internet users' creations on the chopping block. Internet service providers are increasingly targeted by million or billion-dollar lawsuits under contributory copyright infringement. They will be forced to implement preventative anti-copyright infringement measures to remove potential infringing content. Already, ISP's content moderation systems are being mishandled and abused, which will only mean worse things for users if the burden of content policing is fully placed on service providers. Research methodology. For my research, I identified both articles and legal briefs. In my search, I first found keywords of interest and then searched several databases to locate my articles. In finding the legal briefs, I first researched recent news, which brought me to the Cox v. Sony case. I also conducted a small survey for my research. This process consisted of completing IRB training, drafting survey questions regarding fair use, and questions to determine the average online behavior of my respondents. Results and discussion. The literature displayed a dour picture. As described previously, the lack of new copyright legislation has led to a messy series of judicial decisions and case law, and ISPs bearing the burden of content moderation. The issue with this is that it is simply not in ISP's ability to properly evaluate infringement reports. At the same time, moderation tools are presently being misused. If cases like Cox v. Sony pass in Sony's favor, these flawed systems will be used increasingly and unavoidably. Additionally, 40% of respondents didn't know anything about copyright law. Although this was a very small survey population, this percentage is still important to consider. If internet users remain unaware of the shifting environment of online speech freedoms, there's a lesser likelihood of change or improvement. Conclusions and recommendations. I believe there are 2 methods of solution to the issues at hand. For the legal change, I believe it's necessary to have a clear, written legal definition of terms like knowledge or material contribution. This would provide clarity and specify the proper legal application of copyright law or case law and protect against wild claims of infringement. I believe awareness must be raised regarding the issues discussed in this presentation, including the legal issues as well as copyright case law's impact on ISPs and content creation. When more organizations and influential people adopt these methods, awareness can spread even further. This subject has room for further research. There's not much literature on the subject of first-hand social or online experiences with copyright policies. In addition, I believe it would be beneficial for more large population surveys to be conducted on subjects like demographic internet usage and false content takedowns by content type or region. And that concludes my presentation. Thank you for listening.